Sharma, Honorable Vice Chancellor of MNLU, Professor Dilip UK, Honorable Deputy Director General of Shipping, Government of India, Mr. Ash Muhammad, and of course, Her Excellency, Dr. Cleopatra Doumbia Henry, President of World Maritime University, my long-standing friend and academic colleague in the maritime field. I would like to take the opportunity to also recognize the presence of Ms. Yu Xiuwei from Dalian Maritime University, who is representing the Dean of Law, Professor Chu Beiping, who's probably the most distinguished maritime lawyer and law professor in China, and has been a distinguished colleague of mine for the last 8 years at Dalian Maritime University. Good day, distinguished ladies and gentlemen. I am deeply honored to deliver this memorial oration in honor of the late Dr. Chandrika Prasad Srivastava to commemorate his life and work. I have been asked to speak on the topic of maritime law and its prospects for India. But before I proceed to do that, I wish to say a few words with utmost humility about my personal association with Dr. Srivastava. Much of what I'm going to say in the next few minutes has already been said by the Honorable Vice Chancellor, but I would still like to crave your indulgence. I first met Dr. Srivastava together with the esteemed Sri Mataji Nirmala Devi at the International Maritime Organization in London in 1983, when I was a member of the Canadian delegation to the IMO. It was a red carpet reception for the delegates attending a meeting of the Marine Environment Protection Committee. Dr. Srivastava was indeed a towering personality, at once gentle and awe-inspiring. In my personal life, he had an overwhelming and lasting influence on my career in the maritime world, and for that, I remain deeply indebted to him. In 1985, he appointed me IMO legal consultant for drafting maritime legislation and advising on establishing maritime administrations in developing countries, mainly to implement IMO conventions. Since then, I have remained an external maritime legislation consultant for IMO and have drafted shipping, port, and marine environmental legislation for numerous countries of both common and civil law persuasions, numbering around 40. In 1989, he appointed me Senior Deputy Director of the IMO International Maritime Law Institute in Malta, of which he was the founder. Even after he retired in December 1989, we remained in touch. In 1998, I was appointed to the ITF chair at World Maritime University in Malmö, Sweden, of which, as you know, he was the founder and founding chancellor. Later, I became Vice President of Research and Director of Doctoral Programs at WMU. In 2008, on the occasion of the Silver Jubilee anniversary of WMU, I wrote an editorial in the WMU Journal of Maritime Affairs, paying tribute to Dr. Srivastava. He had singularity of vision and unrelenting zeal for molding and advancing the post-sea careers of maritime professionals of the developing world. That was probably his most inspiring and unique characteristic. He planted the seeds of the organic tree of higher maritime education, which eventually culminated into the establishment of World Maritime University. For training and developing of proficiencies of shipboard personnel. He established the International Maritime Academy in Trieste, which later moved to Genoa, both in Italy. At the peak of his international career, he was a personal manifestation of the epitome of eminence in maritime affairs. He was the longest serving Secretary General of IMO and remained Secretary General Emeritus and Chancellor Emeritus of WMU. In later years, I was privileged to visit him once at Sahaja Yoga in Pune at a family gathering where I met his daughter Kalpana and his son-in-law P.K. Srivastava, who later became Managing Director of the Shipping Corporation of India. On several occasions, I visited him and Mataji at the Palazzo Doria in Cabela Ligure in Italy, together with Dr. Karl Lobstein, then president of WMU. I remained in constant touch with Dr. Srivastava and his other daughter, Sadhana Varma, at the Palazzo, where he spent most of his retirement years. As has already been said, he was born on 8 July 1920 in Lucknow. Dr. Srivastava obtained the degrees of BA, MA, and LLB and joined the Indian Administrative Service. He was Joint Secretary in the administration of Prime Minister Lal Bahadur Shastri and was his personal aide. Accompanied him to Tashkent, where the Prime Minister met his untimely demise. Dr. Srivastava later served as Director General of Shipping and was subsequently appointed Chairman and Managing Director of the Shipping Corporation of India. As has already been said, in 1972, he was awarded the Padma Bhushan, and in recognition of his invaluable and extraordinary service to India and his contribution to the maritime world at large, the President of India bestowed on him the second highest national civic honor, the Padma Vibhushan, on Republic Day 2009. There are few, if any, personalities who have in recent memory acquired a stature in public life as elevated and distinguished as that of Padma Vibhushan Srivastava. In recognition of his services and contribution to world shipping, Her Majesty Queen Elizabeth II conferred on him the title of Honorary Knight Commander of the Most Distinguished Order of St. Michael and St. George, KCMG, in 1990. Several such honors, national honors, were bestowed upon him by the kings of Sweden, Norway, and Spain, and by the presidents of Germany, Poland, Portugal, Brazil, Argentina, and Egypt, among others. Passed away on 22nd July 2013 at the age of 93 in Genoa, Italy, and was cremated there. Together with Dr. Rosalie Balkin, then IMO legal advisor, I was the only other person from the maritime world who attended his funeral. Those of us who are torchbearers of his maritime legacy owe him a profound debt of gratitude. I will now speak to the subject of maritime law proficiency and potential in India. In this context, a few words on the historical evolution of maritime law in India should be in order. India enjoys a rich maritime heritage in trade and commerce. We know of the remnants of a dry dock in the ancient port of Lothal in Gujarat, which bear evidence to this day of a flourishing sea trade between that region of India and the Persian Gulf and the Arabian Sea areas. The law associated with India's maritime past is firmly rooted in historical antiquity. In the Manu Smriti, known as the Code of Manu in the West, dating back to 900 BC, there were recorded rules of maritime law pertaining to bottomry and the recognition of the Maritime Contract, which later came to be known as the Finis Nauticum. In relatively recent times, the transition of independent India to sovereign statehood was marked by the adoption of several British institutional foundations and superstructures. Among them is the legal framework characterized by the English common law tradition, within which is entrenched in the Indian judicial system, the so-called Admiralty Jurisdiction, which provides for in rem actions in relation to maritime claims. Admiralty law and jurisdiction derives from the English legal tradition rooted in the office of the Lord High Admiral, who, under royal prerogative granted by King Edward III in 1360, had executive and regulatory jurisdiction over all ships and seafarers under his command and over piracy and prize cases. The admiral was empowered to take cognizance of maritime causes, the substantive law of which had a markedly continental civil law flavor drawn from the Rôle d'Oléron, incorporated into the Black Book of Admiralty. It was distinctively different from the common law, which led to serious rivalry between the common law and the Admiralty jurisdictions, and the eventual demise of Doctors' Commons, the bastion of Admiralty practitioners and jurists who were civilians. The legacy of the Admiralty law and jurisdiction, which India has inherited, is encapsulated in what I just said. It is within the bounds of this jurisdiction that maritime cases are dealt with in India, including maritime criminal matters. The infamous Alondra Rainbow piracy case turned out to be a landmark decision of modern times involving coastal zone piracy. Fast forwarding to modern times, in international maritime law academia, the name of the late Padma Vibhushan Dr. Nagendra Singh stands out as the most illustrious of Indian maritime law scholars and practitioners. He bore the rare dual distinction of being both a jurist and an author of superlative stature and accomplishment. Volumes 1 to 4 of the British Shipping Law series on international maritime law conventions, and volume 13 on ship owners, which he co-authored with Raoul P. Collinbow, are among the most authoritative works on those subjects. He was a member of the United Nations International Law Commission from 1967 to 1972, and of the Permanent Court of Arbitration at Den Haag from 1967 to 1983. As a distinguished jurist, he was a member of the International Court of Justice for 15 years, from 1973 to 1988, and held his presidency from 1985 to 1988. He received master's and doctorate degrees, substantive and honoris causa, from numerous universities at home and abroad. It is difficult, if not impossible, to identify anyone of such outstanding greatness in the modern milieu of maritime law, internationally or in India. In my humble opinion, this scion of international maritime law, who in his lifetime was larger than life itself, is more than rationale enough for India to pursue world-class maritime law in the current climate of economic advancement. There is ample prospect for that to happen. Modern Indian jurisprudence is remarkably prolific and enjoys quite a high degree of repute and recognition, particularly in the areas of constitutional and administrative law. In the common law countries of Asia, such as Bangladesh, Sri Lanka, Myanmar, Malaysia, and Singapore, that degree of international recognition is somewhat less in the private maritime law field, that is, in shipping law. It is pointless to probe into the reasons for the extant state of affairs. Rather, it is important for us to recognize the immense potential for developing the legal side of the maritime sector in India, which can lead to a promising career path for the younger generation of aspirants in the maritime field. This virtually unlimited potential can be realized through sound university education in maritime law, which, apart from the admiralty and commercial branches in the private law side, also consists of international law of the sea and the regulatory maritime law characterized by the numerous IMO conventions, as well as the Maritime Labor Convention 2006 of the International Maritime Labor Organization. Incidentally, the Jawaharlal Nehru University in New Delhi is very well known for its higher education offerings in the discipline of international law of the sea. While maritime transportation is largely a commercial activity, there is a vast and inescapable international regulatory dimension to it. Thus, in my view, legal education in regulatory maritime law must be fully explored by relevant institutions. A word of caution regarding the perception of what is maritime law. Those of purist public law persuasion often refer to maritime law as belonging to the genre of shipping law and would fervently distinguish it, mistakenly in my opinion, from law of the sea. In consonance with the views espoused by Frederick Sanborn going back to 1930, the distinguished Professor Edgar Gold of current vintage, and others, I subscribe to the holistic notion that maritime law encompasses both the public and private law dimensions of that discipline. We may curiously observe that etymologically, the word maritime, derived from the Latin, means of or pertaining to the sea, which is an expression quite broad and accommodating, free of any public law, private law dichotomy. In this regard, it is refreshing to note the all-embracing definition of maritime law given by Professor Schönbaum of Tulane Law School. He says, it is the entire body of laws, rules, legal concepts, and processes that relate to the use of marine resources, ocean commerce, and navigation. Thus, boxing maritime law into two watertight compartments and labeling them public and private, in my view, is superficial and counterproductive, especially given the hybrid areas such as maritime labor law and nationality and registration of ships that defy any neat categorization as public or private. Needless to say, maritime law education must be followed by professional legal training and practice. To that end, it is necessary to gain the support and involvement of both the public and private maritime sectors. The shipping industry and its associated collaborators, such as charterers, cargo owners, financial institutions, marine hull and machinery insurers, and protection and indemnity associations, crewing agencies, public authorities, institutions of higher learning, the regulators of legal qualifications, and the legal profession itself must all play their respective roles. The advancement of maritime affairs, whether public or private, depends to a large extent on the availability of maritime law expertise in the country. Hitherto, this expertise held by Indian nationals resident in India as well as expatriates living abroad has been largely obtained from academic and professional institutions in the Western world. That said, there are some who have developed their expertise in India through homegrown experience in the practice of maritime law without the benefit of formal legal education in that field. In this vein, it is notable that India is perhaps the most sought after professional crew supply country in the world, because technical maritime education and training in India is absolutely world class and has been so for many decades. In contrast, maritime law education is markedly deficient or still in a relative state of infancy when compared with Western maritime law institutions and even some in the continent of Asia, such as the National University of Singapore, which enjoys world-class ranking among the top 100, Korea University, Korean Maritime University, Chungang University in South Korea, Kobe University in Japan, and of course, Dalian Maritime University, which is my home university at the present time, and Shanghai Maritime University in China, just to name a few. In Japan, China, and South Korea, a number of former maritime academies, or nautical schools, if you may, converted to universities. They have prospered as comprehensive universities while retaining the focus on maritime disciplines. Kobe University of Mercantile Marine, KUMM or KUM, now known as Kobe University, has a history of some 150 years. Dalian Maritime University is now 113 years old. Shanghai Maritime University and Korean Maritime University, they're all striking examples of institutions which have programs ranging from seafarer training in conjunction with bachelor's degrees through master's degrees, right up to doctoral and postdoctoral level studies and research. All of these above mentioned universities have developed programs in maritime law in earnest within their respective law faculties, especially Dalian Maritime University, with which I am now presently associated as Professor of Law and Foreign Expert. Other sources of inspiration are IMLI and WMU. IMLI confers an LLM in International Maritime Law and a PhD. I was the founding senior deputy director and professor of maritime law there for the first 7 years, right from its inception. It is the second of the two IMO institutions of higher learning, WMU being the first and apex institution, and truly an international center of excellence in all maritime disciplines, including maritime law at postgraduate levels. The maritime law and policy specialization offered at the master's level, designed for executive level decision making in both public and private maritime law sectors, and the PhD program in maritime affairs, including maritime law. I am proud to say that I was instrumental in the establishment of these programs. I was also instrumental in setting up the joint PhD in maritime and commercial law with Swansea University in the UK and the joint LLM in maritime law with Lund University in Sweden in 2007. I was also instrumental in establishing an independent PhD program at Lund University, The first graduate of that program is presently a senior lecturer there. A bright young Indian maritime law PhD of mine from WMU was a lecturer at Lund University. He is now an associate professor at University of Gothenburg. I'm delighted to say that among the alumni of WMU, the Indian students were among the brightest and the best, at least during my time. And at that time, at WMU, a graduate from China was the first female to win the Chancellor's Medal, and an Indian Chancellor's Medal winner held the distinction of gaining the highest average in the history of WMU up to the year 2011, which was when I retired from WMU. He came from the Indian Coast Guard and is now an assistant professor at WMU. In any developing maritime law system with potential, a desirable first step towards education in that field is the introduction of elementary maritime law subjects as electives in the bachelor's degree course in law, or its equivalent in university law schools and law colleges. This can lead to postgraduate programs at the master's level, providing sound and comprehensive maritime law education, embracing academic and professional needs in the field. Eventually, intensive, innovative, and forward-thinking research leading to doctoral degrees and postdoctoral qualifications can be contemplated. Even more importantly, following the master's specialization in maritime law, serious consideration should be given to recognition of maritime law education by the National Bar Council or association, which will enable qualified lawyers to practice in that field and ultimately also provide adequate maritime law expertise within the national judiciary. The scheme can well be followed in India, where there is vast potential and prospect for development of maritime law. In India, there has been a lack of systematized maritime law education. In particular, private maritime law is an academic area that has hitherto been largely left behind in the Indian higher education milieu, whether within law faculties of universities in general or the national law universities. There is no real specialization in maritime law in an Indian university, including those located in the coastal states of India where there are the major ports. The reasons for the relatively low level of maritime law education are not entirely clear, although some conjectures can be made. It would appear that the status quo in some respects is attributable to a laissez-faire attitude of inertia, that is, an unwillingness to promote change. Happily, however, this now is changing quite rapidly, as I can glean from my recent personal experience, to which I will now refer in synopsis. My first experience was with the West Bengal National University of Juridical Sciences at Kolkata. An exemplary attempt at promoting private maritime law education was instituted at NUJS in 2010 at the invitation of the then Vice Chancellor, Professor M.P. Singh. I was instrumental in setting it up together with Dr. Abhinayan Bashubal, who was at the time lecturer at Lund University in Sweden, working with me. We delivered an introductory course providing an overview of maritime law. It was offered as an elective to current LLB students with the aim of attracting interest in the subject. We hoped that this modest beginning would serve as an impetus and launching pad for the establishment of a maritime law specialization at the LLM level. Unfortunately, that did not materialize. My association with National Law University Odisha happened next, and remains the strongest, perhaps because Cuttack is my ancestral hometown in India. In April 2016, I was invited by then Vice Chancellor of MNLU, Professor Sri Deva Rao, to advise and assist with setting up the Center for Maritime Law. At the inaugural meeting, I was privileged to meet the now late Samareshwar Mahanti, who was a collaborator in the setting up of the center. He is author of the book Admiralty Law and Maritime Jurisdiction in India, for which I wrote a foreword. It is an exceptionally insightful book, the only one of its kind in India. MNLU has produced a remarkable publication entitled Through the Lens of Maritime Law, edited by Pallab Das, a PhD candidate in maritime law at MNLU. I have contributed a chapter in it as well as in the MNLU Law Journal and twice in the MNLU Human Rights Law Journal, where I wrote about maritime labor law. Apart from initiating maritime law training programs for shipping executives and courses in the LLB and LLM programs under the auspices of the center, MNLU regularly participates in national and international maritime law moot court competitions. Recently, in the renowned Jessup moot, MNLU ranked in 4th place in the world out of over 100. In January 2020, MNLU hosted an excellent international conference on maritime law in which I served as a sessions chairman. In June 2020, I was appointed honorary professor of law by MNLU. In late 2020, during the worldwide COVID-19 pandemic, I was invited by the Gujarat National Law University to deliver an online lecture, which I did, on the topic of Admiralty law and jurisdiction in India. Concurrently, at the invitation of Gujarat Maritime University, I also delivered a special lecture at a seminar for senior Indian Coast Guard officials on the public law of maritime enforcement, which involved considerations of legislative and enforcement jurisdiction, in contrast, and maritime security extending to maritime penal law. I also reviewed the syllabus for the one-year LLM course of GMU. Recently, in July 2021, the Kerala Law Academy Law College in Trivandrum held an international maritime law conference at which I was invited to deliver the inaugural address. I was also asked to review and comment on the course scheme and structure of the maritime law program of Kerala Fisheries University, encompassing law of the sea, maritime jurisdiction and admiralty law, maritime and commercial arbitration, shipping law, marine pollution law, fisheries law, carriage of goods by sea, marine insurance, maritime safety and collision law, ports and harbors law, and maritime labor law. I also reviewed the maritime law syllabus for the one-year LLM course of Cochin University. The course contents and structures of all the maritime law programs which I have just mentioned are comprehensive and challenging for young Indian minds. Today, I am invited to speak to a topic close to my heart at this auspicious gathering co-hosted by the Maharashtra National Law University to commemorate the life and works of Dr. C.P. Srivastava, who himself had a legal background and put maritime legislation at the forefront of the IMO agenda in conjunction with the establishment and operation of WMU and IMLI. In all of this, I am deeply impressed with the efforts being expended by Indian institutions to promote maritime law education at the university level and I visualize a sea change forthcoming in the near future. Insofar as the practice of law is concerned, more can be done to boost the profession and inject more maritime law expertise into the judiciary. The few who dominate the field of private maritime law have carved out a niche. Their practice is largely confined to cargo damage claims, disputes relating to freight and related charges, charter party disputes, and ship arrests to enforce maritime claims of sorts. Notably, Admiralty Jurisdiction was originally vested only in the high courts of Mumbai, Kolkata, and Chennai, but it is most encouraging that under the new Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017, this jurisdiction has now been extended to the high courts of Karnataka, Gujarat, Odisha, Kerala, and Hyderabad. If commercial success is the gauge that falls under the watchful eyes of the younger generation of Indians seeking a career in law, then private maritime law is not to be disregarded. To establish a rationale for enhancing maritime law education in India, first, the trend in the emerging Asian economies of Singapore, China, Malaysia, and South Korea must be observed. And second, it must be recognized that even in Europe, the traditional bastion of commercial shipping, there is now a shortage of expertise in maritime law. The Netherlands and Belgium, which are leading maritime nations in continental Europe, public concern has recently been expressed over the dearth of maritime lawyers and inadequate legal education in that field. UK and European continental universities, such as London, Swansea, Gothenburg, Oslo, and Maastricht, to name a few, are increasingly looking to initiate or strengthen their maritime law capabilities. India is a major player in the eastward movement of the world economy, and shipping has much to do with the pace and momentum of that development. India, as a common law shipping jurisdiction with a wealth of history and tradition, can offer itself as a center for numerous maritime law activities ranging from provision of an arbitration venue to a marine insurance market. The admiralty side of the judicial system can be strengthened with advanced expertise in that field of law. There is no reason why the requisite maritime law education cannot be offered by the established as well as the new trendy law universities to meet the needs of modern India. In the course of humbly paying tribute to Dr. Srivastava, I have attempted to highlight the as yet untapped potential in India for a career in public or private maritime law. To realize that potential, specialized maritime law education is needed at the postgraduate level. Given the position of India as an emerging economy in the Eastern Hemisphere, maritime law is a commodity that can no longer be boxed into a watertight compartment with an innocuous label. While young Indians are thriving in the present glamorous realm of information technology, maritime law is being passed by virtually unnoticed. There are numerous opportunities at home and abroad, particularly in new jurisdictions with high growth factors but infant legal systems. Needless to say, government has a formidable role to play in developing strategic objectives and formulating rational policies to effectuate the prospects in maritime law. There is a promising future in maritime law as a career for young Indians, and every effort should be expended to sustain India's position in world shipping and its emergence as an economic force in the years to come. Thank you all for your patience.